Hello and welcome to the first in our series of short videos on legal topics designed to introduce our clients or any potential future clients to areas of law that they might not be familiar with. My name is Alan Douglas and I am the head of the Wills Probate Department here at Hadaway Hadaway. I've been here for around 3.5 years and I am also a member of the Society of Trust and Estate Practitioners, which is a professional organisation for those with specialist qualifications in this area of law. Now, today I'd like to talk to you about wills. Now, we all know that it is important to make a will, but many people put it off. And that's understandable because it's not the most fun thing to talk about, but it is important and sometimes people put it off and sometimes they never get round to it at all. Briefly today, I'd like to explain just why it is so important. The main reason is, of course, that if you do not make a will, then the law decides rather than you deciding who will inherit your estate. There is a strict order set out in the Administration of Estates Act 1925. As you can see from the date of that act, that's a pretty old piece of legislation. It's a pretty old law, and it was made at a time when things like stepchildren, second marriages, or unmarried couples living together were relatively rare. Therefore, that type of fairly common modern family arrangement is simply not accounted for in the Act, and those circumstances are not accounted for if you don't have a will. So your stepchildren would not inherit, and neither would the partner that you might have lived with for many years but never married. However, your estranged son or daughter might inherit, or your second spouse might inherit the entire estate at the expense of your own children. Clearly, there are any number of situations like that, and any number of situations where what the law says would happen is unlikely to be what you would want to happen. Everyone's situation is different, and specialist advice is needed. Making a will also allows you to choose who will act as the executor of the estate, so you can appoint whoever you want to deal with things and make sure that the will is followed when the time comes. You can also choose guardians to look after any young children that you have, and you could set up a trust for any beneficiaries that you consider to be too young to inherit in their own name, or for someone who is, for some other reason, vulnerable, for example, because of a disability. Generally speaking, a will makes things easier for those of your loved ones who are left at a time that they will already be suffering from grief, having lost you. It sets out your wishes clearly so that no one has to guess at what you might have wanted, and therefore it significantly decreases the chances of there being a family argument following your death. It can also make it easier to deal with financial institutions such as banks and building societies. If you haven't got a will, or if your current will is out of date, then the best thing to do is to arrange an appointment to discuss the matter with a specialist solicitor now. Hadaway Hadaway can be contacted on 0191 257 0382 or through our website www.hadaway.co.uk. Don't delay, don't put this off. Make an appointment with me, Alan Douglas, or with my colleague Victoria Richer today. Thank you.